Thank you. Please be seated. Good morning. We're here today in the matter of Miguel Anthony Hernandez versus Lindsay Marie Athey. Our case number 1CA-CV22-0660. We're here today for oral argument. Counsel, each side, you're allocated 20 minutes, but it's your responsibility if you want to reserve any time for rebuttal to keep track of that yourself, okay? We have conferenced the case this morning. We've reviewed the briefs, the record, and we're relatively familiar with the facts, so keep that in mind when you're making your arguments. This is going to be live streamed on YouTube and recorded for posterity. And so keep that in mind when you're making your presentations. Please introduce yourself at the beginning to tell us who you are and who you represent so that the throngs who will watch this later can figure out who's talking for who. I think I've covered everything I need to do, so we'll start with appellant.
Good morning, Your Honors. May it please the Court, Nicholas Boca representing the appellant Miguel Hernandez, who is present here today. Thank you for the opportunity to speak this morning. I'll start with a brief 1-minute introduction. This case arises from the modification of a 2020 family court order. The 2020 order outlines in great detail factual findings of mother's mental health issues that negatively affect the welfare of the child in this case. Quoting Backstrand, these specific findings represent a snapshot of the child's best interest. This snapshot forms the baseline from which future courts assess whether a material change in circumstances has occurred. Father asserts that during the modification trial, mother did not meet her burden for showing that there had been a substantial change in circumstances because she did not address the specific mental health issues outlined in the 2020 order. Father further asserts...
What was she required to do? Is she required to look at every single factual finding and be prepared to dispel that when she appears at a hearing such as your client raised? Or is she required to only follow the orders that the court made in regards to those factual findings? Because you just said they made a lot of factual findings. Well, okay, that's great. But in my mind, the only thing she is responsible for is what's ordered as a result of the court making those findings. So do you think about that differently than how I just said it?
I do. Yeah, and the line of thinking that you were just telling is my understanding of how the trial court analyzed this. There was a discussion on the record about halfway through the trial on page 120 of the transcript where the attorneys were having an open dialogue with the trial court. And ultimately, that's how Judge Allen concluded, that the only requirement was that mother participate in 12 months of mental health treatment with a master's level therapist, provide the CFE to that therapist, and ultimately work on what other mental health issues she wanted to work on during that.
Well, not that she wanted to work on, but that whoever was directing her treatment thought was appropriate for her to work on.
I think that's a better way to phrase it. Ultimately, the counseling the mother engaged in was talk therapy or self-reported therapy, as outlined by Ms. DeSerto, her individual therapist. But I think that that's the wrong way to analyze this. So ultimately, those factual findings, which can be properly categorized as mother's underlying mental health issues, which were the reason for her alcohol abuse, were the reason why Judge Ostrowski very clearly linked those underlying mental health issues to how it negatively affected the child's welfare. So that until she addresses these mental health issues, she's at risk of relapse, which puts the child at potential risk of harm. And he made findings that legal decision-making authority is not in the child's best interest and, equal parenting time.
So was she required to find a counselor? If the counselor who she found apparently didn't think that she had a mood disorder, for instance, was she required then to shop until she found someone who agreed with Dr. Weinstock that she may or did have a mood disorder? What was her responsibility when she's following the order to get the master's level counseling and is sharing Weinstock's CFE with the counselor? What was she to do when that counselor says, yeah, I'm ruling out a mood disorder for you?
I think that her ultimately, she should have pushed for a treatment plan that addressed the 2020 order and ultimately the CFE conclusions and recommendations. Dr. Weinstock, his conclusions and recommendations were based on data collection, analysis, interpretation, a review of all of the parties' mental health history.
And yet the court didn't say, I order you. The court didn't adopt Weinstock's recommendations and say, I concur and these are the recommendations that are ordered.
But the court did. So what the court said was, we have underlying mental health issues that are, based on the CFE from Dr. Weinstock and testimony from Dr. Weinstock to include a mood disorder. Judge Ostrowski, in 2 parts of his order, says that there's a mood disorder here, and the mother needs to address these issues before those restrictions that were put in place by Judge Ostrowski can be lifted. And that's the correct analysis here. And the idea that mother can go to a master's level therapist who doesn't do psychological testing, who's not doing treatment based on scientific methodology, and start changing the conclusions that Dr. Weinstock made that were based on psychological testing, were based on scientific methodology, does not correct the reason why Judge Ostrowski put the restrictions in place.
But if you thought that was the case when you saw Judge Ostrowski's order, because the order just clearly states mother shall participate in mental health treatment with a minimum master's level counselor, provide Weinstock CFE, choose the identity of the counselor, and ensure a counselor can work with her other counselors and that they share information. And later, it says that the court finds that as long as she's maintaining her sobriety, addressing her mental health needs. I guess my question is, if you saw that order and thought that it was inadequate and wanted the court to add the things that you just rattled off very quickly as what your thought was, what would help, should you have moved to reconsider? Should you have given the judge a more specific order? And again, I'm just kind of honing in on, you've got an order that could be interpreted many different ways, but the court here, in the case that we're looking at, interpreted it in a way that she met the standards of the orders that were given. Even if you have a different interpretation of what that could have meant, should have meant, whether this was effective, what she did, and how are we to look at that with our standard of review as to the factual findings the court made?
So I think that you can look at it in the context of the Backstrand Directive, that the factual findings, the required findings under 25403, that forms, again, the snapshot that is the child's best interest and the baseline from which future courts are going to determine whether or not modification is appropriate. It doesn't say under Backstrand that the trial court in this case is just to look at a directive from Judge Ostrowski. It says is to consider the entire order and the factual findings, which include very specific conclusions that mother has mental health issues that need to be addressed.
Aren't you really asking about 2 different issues, though? I mean, it seems to me that the threshold issue and the thing that your brief focuses on is whether there was a change in circumstances, right?
That's one of the arguments, yes. That's a threshold issue, yes.
Did you make the second argument about whether the court were challenging the actual best interest finding?
There's an argument that mother did not meet her burden, and that even if there's a finding that mother did, that the evidence doesn't support the conclusion that the trial court made.
Where's that in your briefing that you say that the court erred as to their 403 findings in the case before us? You say we never should have gotten there, but where do you say that, given that we did, here's where the court erred in the 403 findings they made that led us here?
There's an argument that the findings that...
No, I'm asking where in your brief. Oh. Show me in your brief where we're seeing that you're making a separate argument that the court's 403 findings, that even given that there shouldn't have been a substantial and continuing change of circumstances, we shouldn't be to a place of 403, that what the court did analyzing 403 was error that we can reverse if we agree with you.
A moment. I don't think I say it in that specific way. I think we challenged the 2 findings that the trial court makes. One being the finding that mother addressed all of the issues in the 2020 order, and therefore a substantial change in circumstance warranting modification occurred. That's the first finding, right. And that's not in the 25403 findings. Right. That's just the finding. I think that finding in itself is insufficient because it's a legal conclusion without a factual basis.
But what I'm asking is, do we even have authority based on your briefing? If we say, yeah, there was, we disagree, we think there was a change in circumstances that led us here, but the court's conclusions about who should have the kids when and under what authority, we can reverse.
I think you have the authority to look at the evidence and determine that you cannot reach the conclusion that the trial court did based on the evidence.
How do we do that if you haven't raised it?
It was raised.
The 403. So, and again, that's why I'm trying to direct, because all I see, and it's, you make a compelling argument about what you make the argument about whether the court should have even gotten to 403. But I'm not seeing specifically in your briefing that you say if they did reach 403 findings, those findings were error, and therefore this should be remanded for a new determination of legal decision-making and parenting time.
I think the way we frame the argument is that ultimately, Mother did not address the issues that were outlined in the 2020 order, and that the evidence doesn't support the conclusion that she did.
And they're certainly interrelated. I mean, the arguments that you make towards change in circumstances are some of the same issues that I guess you're asserting now are impliedly related to the 403 findings.
Yes, they're absolutely interrelated, but honing in on the finding that I just described from the trial court is not within the 403 findings, and it is interrelated. So the first main argument that you've already identified, and I appreciate that, is that Mother didn't meet her burden. Okay. The second argument is that even the court finds that Mother did, the evidence doesn't support it.
I want to focus, and I'm the one who distracted us from your original argument, but focus back to the change in circumstances. And maybe I think too simply, but is your argument that because she didn't comply either with the express or implicit terms of the court's order that the court cannot find a change in circumstances?
Yes. And that
is there support for that rule? Because I could certainly see a trial judge going, I'm ordering you to do this, whatever this is.
Sure.
And a year later, she comes back and says, I didn't do this, but here's the 8 things I did do. That could be a change in circumstances. Is there any case or something you can point me to that says, no, as a matter of law, you cannot find a change in circumstances if she didn't do exactly what the court said?
No, but in the context of this case, that was what was at issue. It wasn't that she was doing other things and that was the basis for her argument for change in circumstances. It was specifically related to the issues outlined in the 2020 order.
Even in the issues, I mean, the deposition of the therapist said she's making progress. Why can't that alone, even if it falls short of everything the court had asked her to do, judge could say, and I would not have probably reached the same decision as this trial judge. But that's not my job. Our job is to defer to their findings as to what's in the best interest of the child, when change of circumstances, all those types of things. So how do I sit up here not having heard that entire case and all the evidence and everything and say, no, the fact that she hadn't had any problems for another year, she'd gone to the therapist testifies she's making progress. How do we say, nope, judge, you were wrong to find a change in circumstances?
Of course, so 2 things. So I do agree that this panel does defer to the trial court's factual findings if there's competent evidence to support it, but not...
And also, we infer that the court made every factual finding necessary to support its decision, right?
If there's competent evidence to support it, yes, but not the legal conclusions that those factual findings are based on.
So what is the legal conclusion then that's wrong?
That Mother's addressed the concerns outlined in the 2020 order.
But again, sorry to hang up on this, what is your authority that she has to fully address the concerns? Why couldn't progress be enough?
And let me give you a couple hypotheticals to make that point. Say that in the midst of all this, these were the circumstances of Mother, and your client had gotten the DUI, and they come before the court, and the court has to make best interest findings. And could they not give Mother any more time if there were other changed circumstances, given the facts that were here?
Potentially, but I think that the conclusion that was reached is even just illogical. I mean, the idea that there are conclusions and recommendations from a comprehensive family evaluation that outline very specific issues that Mother needs to address, she doesn't address those on any level.
Well, that's a little bit of an overstatement.
She doesn't address those with significant progress, and clearly, both by her admission and by Ms. DeSerto's admission, doesn't address a mood disorder, doesn't address a personality disorder, and that those are the things that Judge Ostrowski listed to negatively affecting the child's welfare. How can you reach a conclusion that those things are now okay?
So my second hypothetical is, in this case, there was a significant change in where the kids go and who has authority over them. But would mother not have even had a right to come and say that she'd been barred from having any contact with the children? And this was the CFE that was based on, is that you shouldn't have any contact. And she comes back a year later with this same record and says, I want some supervised contact. And in order to change parenting time, the court would still have to make the same findings about there being a substantial and continuing change in circumstance. So under your scenario, or tell me why I'm wrong, she couldn't even come back to have a little bit of a restriction lifted or get an incremental change in parenting time based on what she'd done thus far. The court's hands would be tied and say, well, you didn't finish every single little thing here, so no, I can't even give you supervised parenting time when for the last year you've had none.
I don't think that hypothetical applies to this case because the specific findings in the 2020 order were related to joint legal decision-making authority and equal parenting time. And so mother was getting some amount of time. And
yeah, but I'm giving you, which is what we have to try to do, is think if we're making some rule, how is it applying to other cases? What are the unintended consequences? And I'm saying, if you say she had to dot every I and cross every T before she could get back into court, before she could open up 403 findings, she couldn't even go from no parenting time to supervised parenting time without a court saying that there'd been that change, right? I mean, there's no way for her to get a change without the court making that baseline determination.
I think that's right. If ultimately the 2020 order, there was a finding that mother's mental health issues, and the ones specifically identified, were so severe that it would be harmful for her to have any contact with the child, then yes. In order for her to come back to the court and say, I want some contact, she has to address those concerns that led to the no contact order. That's the logical conclusion for this. The idea that she can seek...
But again, to the question I was asking earlier, is there any authority you can point me to that says, no, you have to completely address them, progress can't be enough to be a change in circumstances?
I think not on point for how you're describing it, Your Honor.
Yeah, and again, I may be just too simplistic in this, but it seems to me that a trial judge is entitled to say, I know what I said a year ago, but you've been good for a year, and you've made progress as evidenced by your thing, and it's not as much as I would have hoped, but it is a change in circumstances, so we can now reevaluate some of these things. Am I missing something?
I understand what you're saying. I mean, I think, but the record doesn't support the progress that was necessary to address the issues before. The sheer fact that there was progress is not sufficient. The counseling that she was engaged in, again, Mr. Turtle wasn't addressing issues that ultimately needed to be addressed to make sure that this child was okay. And that's problematic. And, Your Honors, I'd like to reserve the rest of my time for rebuttal.
Actually, before you sit down, I'd like to raise one issue about attorney's fees. So we have a decree that includes 78B finality language, or that cuts off claims, right? And then the award of fees is left outstanding, the actual award. So the determination, the entitlement to the fees is dealt with in the decree, but not the award. Do we have jurisdiction over that issue even?
Not if it was not rendered a final judgment with no issues remaining.
Okay, thank you.
Thank you.
May it please the court. My name is Erica Levitt, and I am representing Lindsay Athey in this appeal. This is a simple custody case where the court has jurisdiction and discretion to determine whether or not a change of circumstance has occurred and what is the appropriate parenting time for a child. And that's exactly what this court did. Mother in 2020 was told by the court, there's some mental health issues. This is what you need to do. You need to employ a counselor that is a master's level counselor. You need to provide that counselor with the CFT. And that was basically what the court required. Mother was concerned, because this is a very highly litigious case, that she would pick the wrong counselor or do the wrong thing. So she tried to work with Dad, tried to get an agreement. Dad wouldn't play ball. Mom motioned to the court and said, is this counselor good enough?
We understand the record that says that the court ultimately said that she had discretion in how she or who she chose, as long as they met the ABC that was in the order. But I think counsel's real argument here is that counselor was failing to address the specific issues that Dr. Weinstock had pointed out and that were so concerning in the 2020 order. So let's go there.
For sure. Now, the court made very specific, this is what you need to do. She came to the court, she said, I've done this. I've met with the counselor, I've done what I need to do. She went through the counselor, here is everything that I've done. The counselor either said, I didn't think this was necessary, or she's taken control of the issue.
Does it matter that she didn't do any testing? Is that something that matters to us?
No, that was not a requirement by the court, and the trial court had discretion to say, you know what, I maybe would have liked to see some testing, so therefore, no, there's no change of circumstance, or you're not there yet, sorry, try again in another year.
But you acknowledge that the order said, provide your counselor with the CFE.
Correct.
All right. And the CFE had some very explicit suggestions, problems outlined, et cetera, in it.
Okay.
Right?
Right, correct.
Okay. What's the point of telling your counselor to look at the CFE if it's not at least implied in the order that this means these are the things you need to work on and the things you need to do?
But I disagree that it's implied in the order, because the court specifically said, the judge who made the order specifically said, I am not going to dictate the terms of your counseling. Your counselor is to do that. If the court, if it was implied, wanted her to do testing or to work on specific things, the court would have said that. But it specifically said, no, mother, you and your counselor figure it out, and then come back and I'll let you know if you've done it. And so in that situation, that's what mother did. She went to her counselor. She worked on everything that her and her counselor thought was appropriate, came back to the court, and the trial court, in its discretion, agreed. You have done everything. You've taken care of all the issues that Judge Ostrowski said that you needed to take care of. And that's specifically in the order. The court says, Mother has sufficiently addressed all of the issues raised by Judge Ostrowski in the November 2020 orders. So in her presentation of the testimony, she proved to the court that I've done everything. And so Father's statement that no, she hasn't done everything, she didn't meet her burden, is essentially asking this court to re-weigh the evidence, which it can't do because it's a discretionary decision. Did she do what she needed to do? Yes. So Father states that there was no change of circumstance that was sufficient in order to modify the parenting plan, and Mother disagrees. At the time of the 2020 orders, the court had identified some mental health issues that she needed to address. She took a year, she went to counseling, she addressed those issues. That is a sufficient change of circumstance, and the court is within its discretion to find that that was a change of circumstance, and the court does. It specifically says that there is a substantial and continuing change of circumstance, and that let the court go to 25403. And as part of 25403, the court did its job. The court completely...
Do you think that your opponent has raised the 25403 issue properly in his brief? I don't think so, because he never specifically
argues that those findings are not sufficient. He only focuses on whether there's a change of circumstance and whether the court appropriately found that. And the court did, and that's an absolute discretionary issue. And even if this court is to say, you know, the change, or if this court says the change of circumstance was appropriate, the 403 findings are more than sufficient. The court goes through in great detail on why it did what it did, address the mental health. He raises in his reply brief that there was an alcohol issue. The court made those specific findings that everything was fine. And so we've got the change of circumstance.
Right. As for the thing you raised in his reply brief, and I haven't dived into this in depth, but doesn't 403.04 say within the last year? She was outside of that year period by then.
Correct.
Okay.
Correct. So he hasn't challenged the 25-403 findings. They're good. They're exactly what the court needed to do, and they're discretionary. And so essentially this whole appeal comes down to father disagrees with Judge Allen's ruling. Father believes that his evidence is better than mother's evidence. That's not what this court can't look at father's evidence versus mother's evidence and say, well, I like father's evidence better, so we're going to go with father. It's an abuse of discretion standard. And the court was within its discretion to find the change of circumstance and then to order 50-50 parenting time along with legal decision making.
So I believe the argument was that there's no substantial evidence, or I think he put it, no competent evidence to support the finding. So would you like to address that?
Evidence is evidence. If the judge found that mother's testimony and the deposition transcripts of her therapist was competent evidence, the court has discretion to do that. If the court has a lay witness and an expert witness, the court can disregard the expert witness and listen to the lay witness. It's not father's job to decide what is competent and what is not. And the evidence was mother's testimony and the deposition transcripts of her therapist.
Further to that point, is it our job to find what is competent evidence and what is not competent evidence?
Absolutely not. It is discretionary with the trial court. That is the trial courts is in the trenches. They're the ones that decide factual findings. And as long as there's as long as there's evidence in the record to support what the trial court did, then this court has to affirm. And there is absolutely evidence to support what the trial court did. Father just doesn't like that evidence. He thinks his evidence is better, but that's not the standard. Everybody thinks their evidence is better. That doesn't mean that it is.
Your client was awarded fees for a small portion of the litigation related to a witness and the decision not to call that witness. Is that correct?
Correct.
Okay. Did you ever get that fee, or did you ever finalize that fee award? Submit an application, get a final judgment on the fee award?
I believe so.
Okay. Our record doesn't reflect that I saw anyway. How much was the award?
I don't know off the top of my head.
Do you agree or disagree? So I don't want to lead you, so I'll give you both options. That the court certified the fee, what I'm calling the fee entitlement decision in the order that was appealed from, correct?
Correct.
Okay. Under 78B.
Correct.
Is it proper for the court to have certified the fee decision under 78B?
It is proper. It wouldn't have been proper to certify it under 78C, but under 78B, because that's the portion of the rule that says if there's still some outstanding issues.
Doesn't 78B say that fee awards are a separate claim?
Yes.
And by certifying the entitlement, what I'm calling the entitlement decision, and now I'm instructing you to call the entitlement decision. So we have the entitlement versus the amount. Didn't the court bifurcate that claim, the fee claim, by certifying it in the initial order?
Did the court bifurcate by signing under 78B?
Yes.
Yeah, I guess you could say that.
And don't we have lots of cases that say you shouldn't bifurcate claims? You don't certify a claim under 78B until it's final.
Yes,
Thank you.
you're welcome. Now, in this case,
Actually, let me ask you one more question.
Of course.
Sorry.
you're fine.
And I never sat as a Superior Court judge on family court, which probably is reflected in some of my decisions out of these cases. But how does that work? Do you guys submit a request for 78B findings on the decision? Because I understand completely the desire to certify the parenting time, all those decisions that we really want. There's no reason for delay. But how does that work? Is that a standard form that they issue in Maricopa County, or do you guys ask the court to certify those decisions, or how does that work?
In a fee
The entire
issue?
thing. Do you have to request 78B for the other decisions, or does that just happen as a matter
Typically,
of
the
course?
courts just do it on their own.
Okay. All right. Now I'm done. Thank you.
So with regard to change of circumstance, again, we believe that the court was in its discretion to find that there was a change of circumstance. And so it was appropriate for the court to make the parenting time orders. Father argues in his opening brief that the court should view the 2020 order as under legislative review. We believe that that's inappropriate. With regard to fees, the court, again, this whole appeal are all discretionary issues. And so the court was well within its discretion to find the way that it did. And mother requests that this court order her fees in this case. The court was clear, the court was within its discretion, and the court had the ability to do what it did. Father, unhappy with that, used his opening brief to essentially cry to this court that it was unhappy with that he was unhappy with what the trial court did. In his opening brief, there's multiple sections that have no legal authority, and it's an unreasonable position that he took. And so mother requests that she be awarded fees for having to respond to this appeal.
Trial court didn't find that he behaved unreasonably, except for that little narrow split. So
Correct.
if he didn't behave unreasonably low, and he's asking us to review that decision, the underlying decisions and argue some of the same things, how can we find it unreasonable now?
The court said it was right on the border of being unreasonable. Didn't officially find it unreasonable, but said it was right on the border of being unreasonable.
So is there an authority for this border cases? That you're
No. So then he comes to this court, and he asks this court to reweigh evidence, which this court cannot do. If he came to the court with legal arguments that this court could do if there was a mistake in law, if the record really wasn't supported by any evidence, that's a reasonable position. Instead, he comes to this court and he says, "Court, I don't like what the trial court did. Can you fix it?" That's not this court's job, especially not in
His
custody.
argument is a little more subtle than that. It is that there was substantial evidence on one side and less compelling and less competent evidence, in his words, on the other side. So
In his words, but that's not fact. He didn't have an expert witness. It was his testimony versus mother's testimony. So the fact that he comes to this court and say, "I have more competent evidence," is again unreasonable because it's not. It's his opinion. He thinks he put on the better case. Judge Allen disagreed. And so coming to this court and telling this court, please reverse what the trial court did, despite the fact it's a discretionary decision, is, in my opinion, unreasonable. Like I said before, his brief, there's not a lot of legal authority, and in parts, there's none. That's an unreasonable position to come up to this court because the rules state that you have to develop your legal arguments. And so for those reasons, we believe that Father is unreasonable and this court should award fees. Unless this court has any other questions for me, I will rest my case.
thank you. First time someone's rested a case in front of me out here, but I understand what you mean.
Can I ask you one question as you're starting?
Please.
It always felt like the substantial and continuing change was just cracking open the door so that you could hear the broader argument. And of course, you have to meet a threshold to get there. But, I mean, the court in this case could have said, yeah, there's a substantial and continuing change in circumstances in that mom has alleged that she's completed, you know, what she said, that she's maintained 2 years of sobriety, she's continued substance abuse counseling, she's participated in the co-parenting therapy, completed GUI. And the court still could have found that it wasn't enough in the 403 findings to say nothing should change. Even given that she's done all these things that crack open the door, the court was still free to make findings that nothing had changed in regards to the children's best interest as to mother, correct?
Yes.
Okay.
Counsel, I want to go and hit back on something that that was raised by Ms. Levitt, which was that Judge Ostrowski's order again, not Judge Allen, Judge Ostrowski.
2020, yes.
Right, but in his order regarding the motion to approve Ms. DeSerto, at the end says, quote, furthermore, the court will not dictate to the counselor his or her treatment plan for mother. The counselor may determine the frequency of the sessions as needed and appropriately treat mother. Isn't that a little in opposition to the argument that there were specific things in the CFE that the court insisted needed to be dealt with before it would find change of circumstances? Doesn't that not line up?
Not necessarily. I think that second sentence that you quoted is informative. It talks about the frequency of treatments. Obviously, the court's not going to micromanage the frequency. But the idea that Judge Ostrowski outlined with specificity, intentionally outlined very specific mental health issues and is going to send mother to a counselor and be like, treat whatever you want. Not these issues that ultimately led to the barriers that I put in place, but treat whatever you want. Is not the right conclusion. And briefly...
Counsel, actually, because both my colleagues here kind of hijacked your 3 minutes that you'd reserved, I'm going to give you an extra full minute and a half to make whatever rebuttal you want to make.
Thank you very much.
Hold on. Let's...
Thank you.
And I said hijack with all due deference and respect to my colleagues. I didn't mean it.
No, I appreciate the questions, absolutely. Regarding the argument about the sufficiency of Judge Allen's findings, we make arguments on pages 20 through 21 the opening brief, and then pages 23 through 26. In terms of just some things I wanted to address, I don't see how this court can find that Judge Allen was okay in reaching the conclusion that he did. There's a recommendation from Dr. Weinstock on page 73 of his CFE that says mother has issues or other concerns about a mood disorder and personality disorder, and these issues need to be addressed in individual therapy. It is definitive that Ms. DeSerto did not address this. It is under oath that mother indicates that she did not address these issues. The idea that very direct recommendation from the CFE that's supposed to be...
But the CFE was never made in order of the court.
But within Judge Ostrowski's order are two findings that mother has a mood disorder, and that mood disorder led to her underlying alcohol abuse issues and again rendered her potential risk of relapse so high that she's potentially at risk of harm to the child, and then concluded that joint liver seizure making is not in the best interest of the child, and equal parenting is not in the best interest of the child. So the idea that mother doesn't have to address that issue and then can still meet her burden, it's wrong from our opinion. So, okay. Thank you very much for your time.
All right. Thank both counsel very much today for your arguments and presentation. We will take this matter under advisement and issue a written decision in due course. We are adjourned.